Chairman, thank you to the witnesses who have come here this morning. Thank you for everyone who has come to join this hearing on a very important topic. I'd like to talk about three different issues concerning Stand Your Ground legislation. The first is the difference between serious efforts to stop violent crime and efforts to advance a political agenda. I've spent much of my adult life working in law enforcement and emphatically agree that law enforcement should be vigorous, going after violent crime, protecting the innocent, protecting those who are preyed upon by violent criminals. Indeed, one of my most significant criticisms of this administration's enforcement of justice is that they have not made prosecuting gun crimes a priority. In 2010, over 48,000 fugitives, felons, and other prohibited purchasers attempted to illegally purchase a firearm. And yet, out of over 48,000, this administration prosecuted only 44 of them. In my view, that is utterly indefensible. If you have felons and fugitives attempting to purchase illegal firearms, we should be going after, investigating, and prosecuting each of those cases. Let me reiterate, out of over 48,000, this Justice Department prosecuted only 44. Likewise, the prosecution of violent gun crimes has dropped significantly from a high of over 11,000 in 2004 to a low in 2012 of 7,774, which is a 29% decline. If we were to put action to all of the rhetoric given about stopping violent crime, we would again put priorities to prosecuting those who commit crimes with guns. Unfortunately, there are many in Washington who seem more driven by advancing a political agenda than actually putting in place common sense steps to stop violent crime. And that leads to the second point I want to make, which is that in our federalist system, criminal law is primarily given to the states to enforce, and state self-defense law is not in our constitutional system the responsibility of the federal government. The federal government doesn't have the jurisdiction, doesn't have the constitutional authority to determine what the substantive criminal law should be in each of our 50 states, and indeed it is quite fitting with the Founders' design that each of those 50 states would make different judgments, different decisions based on the values and mores of their citizens. And so that does raise the question as to the purpose of this hearing. If it is not within Congress's jurisdiction to legislate substantive state criminal law, it raises whether there may perhaps be a broader political agenda behind the hearing instead. The third point I would make is that self-defense is a bedrock liberty of every American. And I would note, this is not a new concept. Indeed, the U.S. Supreme Court in District of Columbia versus Heller stated the inherent right of self-defense has been central to the Second Amendment right. Now, some who get their news from the modern news media may believe that was a new creation of the modern court. I would note that that idea has been around from the founding of this nation. Indeed, Justice Harlan, for a unanimous Supreme Court in 1895, stated the following, quote, "He was not obliged to retreat, nor to consider whether he could safely retreat, but was entitled to stand his ground and meet any attack on him with a deadly weapon in such a way and with such force as, under all the circumstances, he at the moment honestly believed and had reasonable grounds to believe was necessary to save his own life or to protect himself from great bodily injury." The Declaration of Independence begins with the right of life, liberty, and the pursuit of happiness given by our Creator to each of us. And if an individual is confronted by a violent aggressor, the right of self-defense is an inherent right in each of us. And the notion that critics of these laws put forth, that if you're attacked on the street by a violent attacker, you're obliged to turn and run, rather than to defend yourself, is a notion that is contrary to hundreds of years of our jurisprudence and to the rights that protect all of us. I would note also that the chairman suggested a racial disparity. Look, the problem of violent crime in this country is enormous, and tragically, minority communities bear much of the cost of violent crime. Minorities find themselves at times aggressors, but often victims of violent crime. And I would note, in Florida, the data show that African American defendants have availed themselves of the stand your ground defense more frequently than have Anglo defendants. According to press reports, 55% of African American defendants have successfully invoked the stand your ground defense in prosecutions, compared to a 53% rate in the Anglo population. This is not about politicking. This is not about inflaming racial tensions, although some might try to use it to do that. This is about the right of everyone to protect themselves, to protect their family, and I will tell you, given a choice in a confrontation between a violent aggressor attacking an innocent civilian, I, for one, will always, always, always stand with the innocent civilian. Now, we have a system of justice to determine if that is the facts in any particular circumstance, but notably, the stand your ground defense only applies when it is a violent aggressor attacking an innocent defender. If it is not, the defense doesn't apply. So this is a rule that only applies to protect innocent victims from violent aggressors, and I find the notion that we say if you and your family are attacked on the public street, you don't have the right to defend yourself, I find that an astonishing proposition, and one that I certainly hope members of the U.S. Senate will not advocate.